So now we turn to what may be the most important aspect of sexual harassment for you guys as you go into business. You must know that an employer sometimes may have liability for sexual harassment. Now, courts have struggled with this issue of employer liability for sexual harassment. They have struggled to define what it is that an employer must do, because they face a situation: is sexual harassment like a negligence tort in which the employer is responsible, vicarious liability, that the employer is somehow, or the employer was in a better position to stop the activity than the plaintiff? So are we going to treat it like that? Are we going to treat it like vicarious liability, negligence liability? Or should we treat this as we treat intentional conduct outside of the scope of employment? Remember, that's the defining concept for vicarious liability. Did the act occur within the course and scope of employment? So if you are driving a beer truck and you get drunk one day and you're out making deliveries and you run into somebody and harm them, then that is the employer's going to be liable for that, because you were out doing the employer's duty while in the course and scope of employment. If instead you broke into the facility late at night and stole a truck and went out and got into an accident, the employer's not going to be liable because it's not within the course and scope. So the courts had to face this question of, is sexual harassment, is it like negligence or is it like assault? Which model are we going to use in terms of holding the employer liable? And they could have chosen either way. They could have chosen a strict liability standard that says employers are always liable if sexual harassment occurs. Or they could have chosen a standard that said employers are never liable, that sexual harassment, unless the employer hired the person to sexually harass employees, then it wasn't in the course and scope of employment. And therefore, no liability ever. So those are the two positions, and instead the court system has decided to sort of split the baby there, that if supervisors created a hostile work environment, then employers are going to be liable. If the hostile work environment was created by a supervisor, then employers are liable. The general rule for employer liability is that an employer is liable if it knew or it should have known of the activity. And how do we address should have known? Well, everyone knew. It was common knowledge. The supervisors knew that it was going on. All of those would indicate either that they knew it or they should have known it. So an employer can be liable if it knew or should have known of the activity and did not take any appropriate corrective action. Knew of the activity but didn't do anything about it. That's the general standard for employer liability. And we know that employers are usually deemed to know of sexual harassment if it's openly practiced in the workplace, if it is well known among employees, or if it's brought to the employer's notice by filing a charge. If a charge is filed, then the employer is put on notice of the hostile work environment. So if the employer knew about it and didn't do anything about it, then it's likely to be liable for the sexual harassment. So companies want to manage their risks by acting before the problem occurs. And one of the ways they do that is that companies need a comprehensive, detailed written policy on sexual harassment. And then once it has the policy, it has to disseminate it widely, to circulate it among all the employees, to ensure that the employees were aware of what was in the policy. And a company should have a grievance procedure put into place. These are all indicators to a court that the employer has done what it could do to stop the activity from occurring and to provide a means for the victim of the activity, to provide them with a means of making a claim, of bringing that knowledge to the employer's attention. So when you go to work, your work will almost undoubtedly have a sexual harassment policy. We have one here at OSU. As a matter of fact, you have to go through training, mandatory training, and then you have to update that training occasionally to not sexually harass people. And the reason why is to protect the employer from liability. Companies should think about acting quickly, consistently, aggressively. Follow the policy. Do what it is that you've said you would do in the policy. Act consistently. Don't treat one example differently than another example. Act the same way for every policy. Now, an employer can be liable for harassment by either supervisors, by coworkers, or by third parties, customers, contractors, clients. And employer liability may depend on whether there's been a tangible job action. So let's break this down into those various classifications, and we talk about, was there a employer liability? And we start, was a supervisor toward an employee with a tangible employment action. If that's the case, the employer is strictly liable. The employer is responsible. If the supervisor has undertaken some tangible job action, whether that's a demotion, a promotion, a hiring, a firing, in any of those cases, the employer is liable because the supervisor, in making that job action, was acting in the course and scope of employment. The employer has no defense if there's been a tangible act by a supervisor. You cannot claim that you had a policy, it was a carefully developed policy, that it was disseminated widely, and that you actively executed on the policy. If it's a tangible act by a supervisor, there's no defense. We see this in quid pro quo. If there is a quid pro quo case, the employer is always liable for the acts of its employee. Now remember, quid pro quo implies that there was going to be some job action in response to this demand for sexual activity. And if quid pro quo has occurred, then the employer is liable. On your test, when you see one of those fact patterns, and it appears that the employer, that the supervisor of the employer committed quid pro quo sexual harassment, then the employer's liable. So on your test, there's likely to be a lot of discussion about the policies that were in place and how the policies were acted on, but none of that matters in a quid pro quo case. If there is a tangible job action, and again, that can be a promotion, that can be a raise. It doesn't have to be a negative job action, just some job action. The employer is liable for it. Now, if there is no tangible employment action, if there's no hiring or firing or termination or promotion or demotion, change in hours, change in schedule, if there's no tangible job action by a supervisor, the employer is not strictly liable. The employer can establish that, in fact, it had procedures in place to prevent this from happening. In this case, Burlington Industries v. Ellerth, there was a situation in which the female employee, Ms. Ellerth, worked for a company and was subjected to routine comments, demands for activity. Her boss would say, you know, you need to wear shorter dresses. Her boss would say, you need to meet me at this hotel. Those sort of comments. However, there was never any job action taken. There was never he never followed through on any of the threats to fire her, nor did he give her any benefits either. So in this case, the employer was able to establish that it had procedures in place to prevent this from happening, even though it was a supervisor, and therefore it was not liable. An employer can be vicariously liable, however, if those actions constitute severe or pervasive sexual harassment. So even if there has not been a tangible job action, which would mean it's not quid pro quo, the employer can be liable if the supervisor has created this hostile work environment. It's a delicate issue. For your perspective, when you're looking to determine employer liability, look first of all to see if it was a supervisor toward an employee. If it's a supervisor and there was a tangible job action, then liability. If it was a supervisor, no tangible job action, maybe liability if the supervisor created the hostile work environment. Now, the employer can evade liability by proving an affirmative defense. Now, an affirmative defense in the law is a legal concept in which the defendant who's been sued says, yes, everything you say is correct, but we're not liable. Everything you say, allege, happened, but we're not liable. The classic affirmative defense is statute of limitations. You know, we got in a car wreck. The statute of limitations on car wrecks is 2 years. You file your lawsuit 2 years and a day after it happened. I can say, yes, I was wrong. I was driving negligently. I was speeding. I struck you. I ran a red light. But I don't have any liability. Why? Because you waited too long. So that's the classic affirmative defense. And that affirmative defense exists for employers. So how does the employer prove that even if the conduct occurred, it should not be held liable? The affirmative defense applies if the employer exercised reasonable care to prevent or correct promptly any such sexual harassment. When you look to see the extent of protections against sexual harassment in the workplace, things like mandatory trainings and seminars and webinars and whatever, hotlines that are set up, when you see all those things, it's not simply about compassion. Those are elements meant to establish the affirmative defense, that the employer can't be liable because look what it did to prevent this from ever happening. And if it did happen, they had things like hotlines and phone calls, phone numbers that you can call, even anonymously, and so to give them a chance to correct the alleged harassment. The second aspect of the affirmative defense, you must show that the employee unreasonably failed to take advantage of any preventative or corrective opportunities provided by the employer. If you had a grievance policy, for instance, a procedure put in place, and the employee did not take advantage of that, you may be able to establish that you don't have any liability. You had this policy in place, and yet the plaintiff, the employee, did not take advantage of the protections in the policy. The problem with that, and the reason why the affirmative defense can fail, is really that third word in the second aspect. The employee unreasonably failed to take advantage of it. If the employee can argue that it would not have done any good, the person I was supposed to report the sexual harassment to was my supervisor, was my direct supervisor. If I can establish that I had a reason for not taking advantage of the policy, then the employer may still be liable for the sexual harassment. Coworker harassment. In this case, the employer is liable if the employer knew or should have known of the acts of the harasser and took no immediate corrective action. So again, in your analysis of employer liability, if you look first of all to ask the question, is it involve a supervisor? If your answer is no, then you turn next to, was this a coworker? In this case, the employer can be liable if the employer knew of the acts or should have known of the acts and did not do anything to correct it. And it is the same standard for a third-party harassment of an employee, that if the employer knew of the acts of the harasser and took no immediate corrective action.